So welcome back to Legal Brain. Today, I'm going to discuss the last concept, that is a mistake under the concept of factors vitiating free consent. I have already discussed about, the other factors like coercion, undue influence, fraud, and misrepresentation in previous classes. And this is the last concept, that is mistake of, fact and mistake of law. And as you all know, the concept of, consent is very essential when it comes to entering into a contract. By virtue of Section 13, the consent of the parties are very essential. That means, identity of the mind of the parties, understanding the same thing in the same sense. That is called consensus ad idem. And a free consent is also very essential. And we can say that if any of these elements are there, we can say that there is no free consent like coercion, undue influence, fraud, misrepresentation, mistake is present. That means, the particular consent is not free in nature. And the effect of this particular agreement is voidable, it's a voidable contract. And today I'm going to discuss about what do you mean by mistake. So you look into the screen and try to understand. Section 20, 21, and 22 of Indian Contract Act speaks about mistake. And mistake has been classified into two categories, mistake of law and mistake of fact. So I'm going to discuss in detail what do you mean by mistake of law and mistake of fact. First one is mistake of law. Mistake of law is actually, it is called as ignorantia juris non excusat. That means ignorance of a law is not considered as an excuse in law. That meaning is I cannot plead that I was not aware of this particular law. I don't know the law. I cannot plead that I was unaware about a particular law and I cannot plead innocence. Look into the screen and try to understand. The first point is that a party cannot be allowed to get any relief on the ground that he had done a particular act in ignorance of law. That means he cannot say that I was unaware about the law. I was not knowing the law. I don't know the law. He cannot plead like that. Also, a mistake of law is not excusable and a contract cannot be avoided. When you enter into a contract by mistake of law, later on, you cannot plead that, okay, I was not knowing what law was. You cannot plead that. But mistake of law of a foreign country, not Indian law, the law of a foreign country is treated as mistake of fact and not as mistake of law in India. And again, mistake of law is further divided into three categories: mistake of Indian law, mistake of foreign law, mistake as to private rights of the parties, and which is treated as a mistake of fact. So these are the three different types of mistake of law. And mistake of Indian law is non-excusable, ignorantia juris non-excusat, and mistake of a foreign law is treated as mistake of fact, and the next is mistake as to private right of the parties, which is again treated as a mistake of fact. So these are the different types of mistake of law. Always the mistake of law in India is treated as, it's not excusable in nature. And next is mistake of fact. Mistake of fact is again subdivided into two categories. One is bilateral mistake. Second one is unilateral mistake. And first one is bilateral mistake. So I'm going to teach you what do you mean by bilateral mistake. Section 20 of Indian Contract Act merely speaks about bilateral mistake. And bilateral, which means, bi means two. Bilateral mistake means when both the parties are under a mistake as to the matter of the fact, which is essential to the agreement. And if it is like that, it shall be void in nature. And, the mistake shall be termed as bilateral of, mistake of fact, once when both the parties satisfy these two conditions. The first one is that it should be committed by both the parties. Mistake of this bilateral mistake should be committed by both the parties together. And it should relate to a matter of fact essential to the agreement. It should be something which is the essential element of the particular agreement. I'll tell you an example. For example, like, a person agrees to buy a particular horse, a certain horse from B. And it is turned out that the horse was dead at the time of the agreement. Neither A nor B was unaware about the death of the horse. They entered into an agreement, but they were not knowing that the particular horse was dead at the time of entering into the agreement. So both the parties were unaware about the fact, and this is termed as a bilateral mistake, and the agreement is void in nature. And again, bilateral mistake is again categorized into two, that is common mistake and mutual mistake. And first, I'll be discussing about common mistake. In case of common mistake, once when both the parties, the promisor and the promisee, are mistaken as to the existence of a fact which is so fundamental that it forms the basis of the contract. That means, to form the particular contract, the base element, like the subject matter itself, is mistaken. And there is a common mistake, and then it is void in nature. And in common mistakes, both the parties make the same mistake, and each knows the intention of the other and accepts, but each is mistaken about something underlying and a fundamental crucial fact. Again, there is a landmark case law when it comes to common mistake. That is Bell versus Lever Brothers Limited 1932 case. And in this particular case, it's a landmark judgment. And in this leading case, this case actually dealt with a question whether an agreement is void or not on the ground of a common mistake, And in this, by virtue of this particular landmark case law, the common mistake may be like, as to two concepts. First one is the subject matter of the contract. Second one is the possibility of performing the contract. So I'm going to discuss in detail what do you mean by subject matter of the contract. So in first category, the common mistake as to the subject matter of the contract covers these kind of things. The first one is that mistake as to the existence of the subject matter, and which means res extincta. The meaning is that, both the parties, A and B, their beliefs, about the existence, that something is there, something is present, an essential element is there. They are mistaken about the particular thing. And if this is the situation, the contracts will be void in nature. I'll tell you an example, already I've mentioned about the example about the horse, A agrees to buy a horse from B, a certain horse, and it turned out that the horse was dead at the time of the bargain. So in this situation, the subject matter is horse. And that particular subject matter regarding the existence, whether the horse is dead or alive, that's known as the existence. So in this particular thing, the concept of horse, the subject matter is horse, and both the parties A and B, they were mistaken about the existence of the horse. So if that is the situation and they entered into the contract, and when they get to know that the horse was dead, the existence of the subject matter falls into this particular concept, and the contract will be void in nature. And there is a case law, that is Couture versus Hasley. And in this particular case, this 1856 case, in this case, what happened is that A agrees to sell B a specific cargo of goods, and that's supposed to be on its way from Salonika to UK. And before the day of the agreement, what happened is that the goods were actually sold by the master of the ships. And since, they were fermented. So that was not known by both the parties, the existence of the subject matter. That means, here the subject matter is a cargo of goods. So once when A agrees to sell this particular cargo of goods to B, they were not aware about the particulars, the existence of the subject matter. Meanwhile, before the day of the agreement, it was actually sold by the master of the ships, and because they were fermented, that means those were decayed. So in this situation, neither party was aware about the fact, and the agreement is void in nature. So this is the landmark case falling under mistake as to the existence of the subject matter. And next is common mistake as to the quality of the subject matter. And the meaning is that when there is a common mistake as to the quality of the subject matter, the agreement will be treated as void in nature. And the case law is NICHOLSON versus Smith, MARRITOR, 1947 case, landmark case law. And the facts of the case is that table napkins were sold at an auction with a description that made in the days of Charles I. So in this case, in fact, the original situation was that the napkins were actually Georgian. And it was held that the agreement was void because there was a common mistake as to the quality of the subject matter. The quality of the subject matter was that was the base thing under this particular common mistake. And it was actually of Georgian, but it was written that it was made in the days of Charles. And because of this, the particular agreement was treated to be void in nature. The next category is common mistake as to the quantity of the subject matter. So once when both the parties A and B, they have a common mistake when it comes to the quantity of the subject matter, the agreement will be treated as void in nature. Next is common mistake as to the title of the subject matter, that is a reservoir. And the meaning is that once when a party believes that he or she is having a right to sell a particular property, and the opponent B, the opposite party believes that the other party A is having a right to sell the property. They both believes like that. But this is a mistaken belief that the seller has right to sell the thing, and there is a common mistake between A and B, and it's gonna be an agreement that is void in nature. Like A believes that A is having a right to sell a particular thing to B, and B believes that okay, A is having a right to sell. So if that is the situation, it is a common mistake and it will be void in nature. Next is a common mistake as to the price of the subject matter. Once when the promisor and the promisee is having a common mistake, when it comes to the price of the subject matter, the agreement will always be void in nature. Next is common mistake as to the possibility of performing the contract. So once when you enter into the contract, we have to think about whether the contract will be possible to perform or not. And if both the parties believe that the contract is capable of performing, when in fact, which is not capable of performing, then the agreement will be void in nature. And there are mainly two categories of, when it comes to performing, possibility of performing. One is regarding the physical impossibility, that, physically it is not possible to perform. Second is legal impossibility, which means legally it is not possible to perform. And first one is physical impossibility. The meaning is that it mainly happens once when, the occurrence of some particular event before the contract is concluded and which made it impossible to perform the contract. For example, A agrees to let a hall for conducting marriage of B's daughter. Meanwhile, before the conclusion of the agreement, B's daughter died. And in this situation, the fact was not known to A and B. Okay. In this situation, the contract is void as it is physically impossible to conduct the marriage because the particular lady was died. So there was a physical impossibility. Next is legal impossibility. And the meaning is that legal impossibility arises when the law has been, law prohibits a particular act or, a particular thing before the conclusion of the contract, but the parties are unaware about the prohibitions. Like there is a change in law, or something has been changed, a law has been changed, a new law has been implemented, and so on. If that is the situation, if there is a legal impossibility, the contract will be void in nature. Next one is mutual mistake. So we have already discussed about common mistake and different categories in the common mistake. Next is a mutual mistake. Next is regarding mutual mistake, and it is known as, like, in an agreement, if there is a mutual mistake, if the promisor and the promisee misunderstood each other and their intention, though neither realizes that his promise had been misunderstood by the other. Like both are in a mistake of their intention. Like, when one party intends to sell one thing and the other party intends to purchase some other thing. Like I have already given an example, like I have two cars. I'm planning to want the white color car, and you were thinking about, purchasing the red color car. There was a mutual mistake. And the landmark case law is RAFFLES versus WICHELHAUS, 1864 case. And the case is that A agreed to buy, a cargo from B of cotton, and it was supposed to be arrived in the ship named Expiolus from Bombay. And there were two ships at the same name sailing from Bombay, and, one sailing in October and the other sailing in December. And A meant that the former ship and the B was, thinking about the later ship. So there was a mutual mistake between the parties, and it was held that there was a mutual mistake so as to the identity of the subject matter, and there was no contract. That means I am planning to sell something and you are thinking about buying another thing. There is a mutual mistake, and it is treated as there is no contract under RAFFLES versus WICHELHAUS. Next is unilateral mistake. And the meaning is that when one party to a contract is under a mistake of fact and the contract is voidable in nature. But a unilateral, which means, one person is under a mistake of fact. And unilateral mistake do not affect the validity of the contract unless they concern something fundamental. For example, A agrees to buy certain wheat from B, believing that they were old. In fact, the wheat offered was actually not old, it was new. And the court held that A could not avoid the contract on the ground that he had a mistaken impression as to the oldness of the wheat. So this is regarding unilateral mistake. So the meaning is that unilateral mistake do not affect the validity of the contract unless they concern something fundamental, that is regarding something fundamental about the subject matter. And under that, there are mistakes as to the identity of the person. First one is, the first case law is regarding CUNDY versus LINDSAY. So in this case, what happened is that Balkaran ordered by letters. This particular company has ordered certain goods from LINDSAY and signed it in such a way that LINDSAY believed it came from the well-known firm MACKINNON and Company. So there was a mistake in the part of LINDSAY. LINDSAY got an order offer from MACKINNON, and LINDSAY believed and thought that it came from a well-known another firm, MACKINNON. And the goods were actually sent as per the particular order by LINDSAY, and MACKINNON resold the goods to the next person without making any payment to LINDSAY. And subsequently, LINDSAY realized and get to know that they were dealt with, MACKINNON, not the famous other firm, MACKINNON. And they sued CUNDY for the recovery of the goods, and the House of Lords held that the plaintiff was entitled to succeed when there is mistaken identity, though unilateral, and the contract will be void in nature, which means there was a mistake as to the identity of the person. LINDSAY was thinking that he was entering into a contract with MACKINNON. In turn, it was not with that particular company. It was with, it was like he was thinking that he was gonna enter into a contract with the MACKINNON, but it was with the other companies. So there was a mistaken as to the identity of a person, and if this is the situation, the contract will be void in nature. Next is unilateral mistake should always be depending upon the fundamental and affects the character of the contract, and then the innocent party will be freed from the liability. And next is a mistake as to nature of the contract. For example, there is an landmark case law, Foster versus MACKINNON, and the case is that an illiterate old man signing the pronote, thinking that he was acting as a witness. So there was a mistake as to the nature of the contract. The old illiterate man was unaware about the nature of the contract. If that was a situation, then it is treated as mistake as to the identity of a person contracted with, and we know the nature of the contract, so which will be treated as void in nature. So these are the different types of mistake of law and mistake of fact, again subdivided into different subcategories. In exam point of view, I have covered this area. I hope it's clear for you. If you do have any doubt, do comment below. Thank you for subscribing Legal Brain, and do watch the channel. Thank you.